the first to know Nsem-Pii TV.
Sir, Jebekaya Enche ena John Dramani Mahama se nensa aka petition mako miensa de afri timamufuo bi eho eno enam so ema ne kokote committee ana justice poaman ena eda committee no ano a committee ni nso ewie won report de kokoma John Dramani Mahama na de ha adwene wo se petition no mako miensa ena etimi ekokopie committee na nimba akopɛ ena committee no etimi ehwehwem a won edebre John Dramani Mahama o se wagina so etimi asake former chief justice Yamami Gertrude Araba Isaba Saki Tokonu na ni lead counsel ni lawyer lawyer ni Ayikoi Otoo a ono former attorney general and minister of justice ene papa yi amfa NDC amanyuko no eni agrokra sa Tsikata mu nyina so eka ho na sede ye ni anim no asem no ewo ECOWAS court na ekame ese NDC amanyuko no ede nukre bi esie ewo asem nim eno ena papa ne se ono nso mpene ma NDC amanyuko no led by Tsikata entimi emfasa asem no ensie na bi a omodi sie ECOWAS court bi ano court no ebehuna de yenkontie lawyer ni Ayikoi Otoo.
You agree with Sophia Kufu that, for example, the financial impropriety leg, it was not such a weighty matter that should lead to the removal of a chief justice, right?
I didn't say so. You see what? You also purport to be quoting me. I did not say so. Let me take you through the process that I took them through, including those who sat at the committee. Vomawa was not there. We asked them, was there an audit? And they said yes. Did the audit raise queries? They said yes. Did the spending officer respond to those audit queries? They said yes. Was there a final management letter? They said yes. Did the final management letter refer to any setting? They said no. I have a copy of the final. If you say you have the proceedings, look at it. Audit service management letter on the accounts of the judiciary for JS Judicial Service for the period 1st January 2023 to 31st December 2023, dated 30th July 2024. If you claim you have the full record, read it for yourself and tell me where in this management letter they said they have found anything wrong. The auditors who did the work.
Okay, so your point is that if the audit did not flag the issue, there should not be an issue. That's your point.
It means they agreed with the explanation given to them, including the travel policy and all. They agreed with it and they never came back to it.
Okay.
It was never raised again.
Okay.
I said, I have a copy here.
Yeah, I get that. I get that. Nobody is disputing anything you have said.
Yeah, look through yours and see whether you can find anything on that.
My question to you:
the way to treat an individual.
Yeah. So it's not in controversy. So let's not get to that. My question to you is: your point is that if the auditors did not flag misuse, unlawful, expense or unconstitutional expense, nobody should raise it again.
I am saying that when the auditors come, they look at the record. When they have issues, they raise the issues. Then they give it to the management, whoever it is who is responsible, especially the spending officer. And they ask you for your explanation. Perhaps the thing is there. They didn't see it. So then you explain to them. And once you explain to them, that ends the matter. So the fact that it was even raised in a query does not mean that is the end of the matter, because you are now given the opportunity to respond. Something you have experienced, don't you? So having responded, and they left it in the final management letter pointing out the areas they find the judicial service didn't do well, and this one did not come out. How do you turn around? And this committee, this report was before you. I specifically asked Domelevo, who was sitting there, whether this is not a procedure. He agreed. I think he even said there's a difference between audit observation and audit query. But these days they talk about audit or observation or something.
All right.
This is what happened, and the report is there. So where is this thing coming from?
Right. So let's put the committee in perspective. From the letter to the Chief Justice, which said, in the opinion of the committee, quote, in the opinion of the committee, the travel expenses which the Chief Justice heaped on the Judicial Service when she traveled on holidays in September 2023, first to Tanzania with her husband and second to the United States of America with her daughter, together with the payment of per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. Lawful, it is also unconstitutional. You are saying once the auditor didn't make any such claims, a committee like this cannot be heard to say what they said?
Please don't trivialize it. One of the members of the Judicial Council happened to be Gabriel Court-Fmr. He had always been there with them, taking all the decisions, including travel policy. I explained the last time I was here that because of the judicial independence, they also granted them financial independence and asked them to work according to what they think is best to secure their independence. And therefore, they told them that it is only the Judicial Council that can determine anything which is pertaining to them and not necessarily the executive. Not necessarily the executive. So the travel policy was something that came out from the Judicial Council where Fmr has been serving. And he knows that there was this travel policy which allows the Chief Justice to travel with a person of her own choice, and that whatever, whatever per diem is given to her, the person is traveling with will be given half. These are not stories. They are all there. The Chief Justice's appointment letter stated clearly that she will be entitled to 2 vacations in a year. And she can choose wherever she wants to go. Her duty is to tell them that this is vacation period, I intend to travel. Then the spending officers will work, buy the ticket, do all the protocols, and then give her whatever entitlements are. And then she uses that to travel. I am challenging them. Let anybody bring a document where the Judicial Service or Secretary said, these are your entitlements. And then the Chief Justice said, no, I will not accept it. Give me this rather. Nothing of the sort happened. And I'm saying I've gone through it twice as a Minister of Justice and Attorney General and as a High Commissioner. When I'm to travel, I don't get involved. All I tell them is that I need to travel. They work it and bring it to me. Which is why you have a spending officer who is held liable. How did they change it? With Domelevo sitting there, now saying that she being the overall head. Where has it happened before? That the President of the Republic is being held responsible for the acts of the chief directors of the various ministries because he's the overall executive. Where has it happened before?
The central point that was raised by the petitioner is that in that travel policy, it provides a limit. And it says with an emphasis that the CJ can travel with the security alone. For a foreign travel, the security alone. Then they even impeach the policy by saying that as an Article 71 office holder, it is the president, or is it the other way? No, when committees are set up to determine emoluments,
Yes.
it is the committee set up under Article 71 that determines what you are entitled to.
Yeah.
And anything beyond that is unconstitutional, is unlawful.
Yeah.
And then they quote the CJ herself in at least 2 or 3 different cases where she insists that anything beyond what has been determined by the president or parliament, president for parliament, parliament for president, and so on, is unconstitutional. And it is the reason when Abronye took the case to the Supreme Court about the spouses of presidents and vice presidents getting paid as ministers, the CJ led in that decision and said, you won't even allow, even if Parliament was approving it that way, it will not be allowed. You don't agree with them that you can't fault the committee on this?
I will fault the committee that Tsikata brought a document on travel policy and per diems. In that travel policy, they said the people should be public officers. Then there was a footnote in which they stated that these things we have brought do not affect the judiciary because they are an independent body. He brought it and we pointed that out to him. They were all sitting in the committee, we tendered it.
Okay.
In fact, we allowed it to be tendered and brought it out to show them that it does not apply to the judiciary. Where they stated clearly that their terms and conditions and all those purpose of office should be determined by the council. And I'm saying Puama was a member of the council. Set up the e-service system, which is all IT. E-service.
Okay.
How do we serve processes electronically?
Right. So beyond Mr. Bading, there are several others, the issues of transfer. And Mr. Bading's issue, you know, they find difficulty, even though you may see, as the Chief Justice in her testimony suggests how grave she found it and how she wanted to resolve the matter. This was the record of the day for which there was a pending matter before the General Legal Council, and Ayikoi's lawyers needed that record to make their case at the General Legal Council, and somehow that record gets missing or gets tampered with. And so, you know, the CJ2 becomes very interested in making sure that things are done, bringing in Signals Bureau, but they point out clear laws that dictate how the matter should be resolved without bringing in Signals Bureau and the alleged harassment of the officials. But beyond that, I was making the point about the several other issues, including transfer of judges, where she's accused of acting contemptuously, like not even wanting to obey orders, decisions of the court, where some of the people had gotten a decision of the court in their favor, and she is not interested in implementing. And this Giabo lawyer, whose case was also, you know, pending, and she uses a fiat to sort of, as she's accused, get the courts not to deal with his matters. You think all of these things are not weighty to warrant the conclusions they arrive?
Some say, I'm disappointed. I'm highly disappointed. You told us that you had you had gotten note of the reasons that the committee copies of the reasons that the committee gave for arriving at the conclusion that she should be removed.
The letter.
Did you see any of those things we are talking about here? Have you seen any of them except the Frank something?
They are in the petition that was leaked long ago.
So what? When you look at Article 146, what it says is that a justice of the Superior Court or a chairman of the Regional Tribunal shall not be removed from the office except for one, stated misbehavior or incompetence, or on the grounds of inability to perform the functions of the office. So is it not for you to prove, bring evidence to show the things you are showing that you are required to do, and which one did they accept? All the things we are talking about, did they accept it? I'm disappointed. Why are you bringing that into this conversation? They told us that this is what they have accepted, and that even amounted to stated misbehavior. Where is it defined?
Oh, they have referred to transfer, so they have referred to
I am telling you
the initiation of the appointment of Supreme Court judges.
Please, the copy you said you have intercepted, didn't it tell us the reason?
Of August.
That is 5 days.
To file your written submissions, right?
Yes.
By 25th, you had not filed.
We had not, because we were preparing to start the Shining Stars 2 at the same time.
But the petitioner, as in Daniel Ofori and his lawyers, had filed by 25th.
Nobody told us anything. Nobody. That's what I'm saying. I'm hearing it from you for the first time, because they told us we could file it within a reasonable time.
But you were giving 25th.
Agenda hearings to the 15th of September.
But you had just confirmed to me a while ago that you were giving the 25th to file.
Have I denied that?
Right. So as
we were giving.
Okay, please, I'm informing you.
I don't want this kind of.
No, we are doing just a bit of a fact.
Creating the impression as if I'm telling lies.
No, I'm not suggesting. I won't do that. I won't do that, sir. So I'm saying that on the 25th, the petitioner had filed their written submissions. They filed it on the 25th because that was the deadline you were giving, but you were unable to meet the deadline.
I'm saying to you that they said we should file it by the 25th. 24th, we wrote to them that we were on it, we would not be able to complete, and we needed 1 week.
Okay.
That was the day that Oliver Vomawo's group were also to start theirs. And we said, look, we are settled with 2 of them. One, to write the submission, at the same time prepare to come and meet the Oliver Vomawa people, Shining Stars. So could we be given 1 week to organize ourselves, file the written submission, and then start the hearing?
Okay.
And they told us that day, because it did not involve Tsikata and his group, they were not there. So what they would tell us is that they would give us an advice that we should try and file it within a reasonable period. That is all.
Okay.
And then the entire trial was then adjourned to the 15th to give Shining Stars, their lawyer, and whoever will come sufficient time to come back. What is today's date?
Right. So as I understand, you also were surprised that the committee had come up with a report on one petition when your expectation was that they will wait for the whole, all the petitions to be gone into before they present, as it were, a composite and one address or one report.
Oliver Vomawa was there on the first day when they tried to agree on the procedures they were going to adopt. And he would tell you that what they said was that they had 3 petitions. They would start with Daniel Ofori and adjourn the 2 Sinai. When they are ready, they will call us, give us hearing notices to come, and then we go on with the other ones. So they were only going to start with